All right. Welcome, everybody. I'm attorney Justin Randall with Hooper Law Office, and our topic today is on what you need to do if your loved one needs care soon. So there's a lot of different things that are kind of moving parts when you're worried about somebody you love or care about going into, an assisted living facility or skilled nursing facility. And if that's fast approaching, a lot of moving pieces that can be overwhelming to deal with if you don't have experience dealing with that in the past, or if you've, not quite sure what the right path forward is. So what we're going to talk about today is some of the things that you should be aware about, some of the things that you should be cautious about, and when to seek advice on those sorts of things. Spoiler on that, it's usually as soon as possible, but we'll talk in more detail about that. So a couple quick things before I go into more detail. Again, as usual, this is an interactive webinar. So if you have any questions that come up as I'm talking through things, you'll be able to submit them to the Q&A function of Zoom, and I'll be able to see them come in. So I'll answer them as they come up. Now, just a quick reminder that next week is actually next week we actually have no webinar because of the holiday week, but the week after that, on July 13th, is our in-person public seminar in Oshkosh. So that will be our standard wills versus trust seminar that we kind of go through a big sweeping overview of, what you need to be aware of with estate planning in general, and then also talking about long-term care planning. So if you're interested in attending that, I'd encourage you to sign up as soon as possible, just because space can be limited. So if you're looking to sign up for that, you can go to OshkoshEstatePlanning.com, and that will bring you into where you can sign up for a spot. So absolutely do that if you're interested in finding out more information in general estate planning and long-term care. So when we're talking about, though, diving right into when a loved one needs care soon, there's a lot of misconceptions that I think people have about how to best prepare for that, or, they're getting information from potentially risky places. As always, the internet is not generally the best place to find detailed information about a topic that is very important to you and that you're trying to do some intricate planning around potentially. But when somebody needs care soon, one of the first things that I would recommend you looking into is trying to familiarize yourself with that loved one's estate planning documents, looking at their powers of attorney for finance and healthcare, looking at what their will or their trust, how that's set up, and if that's set up to deal with long-term care expenses potentially. And I wouldn't expect you to know that necessarily without talking to the attorney who drafted them. So that can also be a really important first step, is saying, does this cover what we need? But just because they have that power of attorney for finance or health does not necessarily mean that that is going to be the best fit for them, how it's currently drafted, to help you as the loved one deal with those long-term care expenses or plan around long-term care expenses. Powers of attorney are not all the same. It very much so depends on what's actually in those documents, the authorities that are included in them. So reading through that can give you some semblance of an idea of, is this the right fit? But again, if you're not familiar with those types of documents, it's really important that you talk to an attorney on that, an estate planning or elder law attorney, on, does this document actually cover what I would need to be able to do as a power of attorney agent for my loved one, so that I can help them plan for care, that I can help them pay, with their own assets through, the initial period of care if need be. So absolutely know where those documents are. Ask your loved one if they have them in place, and if they don't, it's really important to get those in place as soon as possible. Those documents, as long as the loved one has capacity, can sign new ones or sign their first ones if they don't have them in place. But if especially the need for care is arising out of something like Alzheimer's or dementia, and there's concern about losing capacity over time, the sooner those documents are put in place, the better, because you want to make sure that the person is still able to sign. And unfortunately, sometimes when they don't have those documents in place and they're past the point of where an attorney would feel comfortable having them sign due to lacking capacity, you can be limited in your options going forward. So it's really important to do that as soon as possible, or know if they exist to begin with. So one of the most common questions we get around, care in general or planning for care is around gifting. A lot of people ask us about, is it okay if I gift the property over to my kids or the home or assets over to them, or is there any amount I can give to them and not have it be a problem? So what they're talking about and asking about with that is planning around Medicaid. Medicaid is what pays for someone's care in an assisted living or skilled nursing facility after Medicare has stopped coverage. Medicare will stop coverage after about 100 days, and they will often try to stop coverage sooner, claiming that the person is not, improving in their quality, or they're not progressing in the rehab part of care. And that then means that that person is privately paying until they are down to the point where Medicaid will start coverage. Medicaid has asset limitations on what someone is allowed to keep before that they will start paying for that person's care. So when people are talking about gifting to the kids, what they're really talking about is how do we get them down to that limit so that Medicaid will start coverage. But there are a lot of issues around gifting if you're doing it without talking to an elder law attorney on strategizing how to best do that, because Medicaid has what's called a 5-year look back period. So what that means is if you gift something, all the assets over to the kids, and then the person immediately needs Medicaid assistance, Medicaid will say, show us what you've given away or done over the last 5 years. Well, that gift that person made to the kids counts against them. And how that works is Medicaid says, based on the value of what you gave away, the fair market value of that, we will give that person a penalty. And that penalty is a number of months that they will not provide payment for their care based on the amount that was given away. So giving without knowing or planning around, prospective planning can be very dangerous, especially if care is needed very soon or you think it might be needed soon. I would not encourage anybody to just start gifting assets away without first talking to an elder law attorney and getting their strategy on it and their advice. So it's very important to be aware that that can be an issue. Speaking of gifts, we get a lot of questions about, isn't there some amount that you're allowed to give per year without it being a problem? What people are referring to in that instance is talking about what's called the gift tax exclusion. Well, the gift tax exclusion is currently $16,000 per person per year. So for gift tax purposes, you could give $16,000 to everyone an infinite amount of people, right, in theory, and you would not have to file a gift tax return. Well, if you go over that amount and you do have to file a gift tax return, all that means is that you lower your end of life estate tax exemption by the amount you went over. So currently, everybody in the state of Wisconsin, because we don't have a state level estate tax, has the federal exemption of $12.06 million. So you have to have more than roughly $12 million to have a taxable estate. So if you go over that $16,000, you lower that amount by the amount you went over. So for the most part, none of us will ever have to pay gift taxes, because that is very hard to do unless you are very, very wealthy and you've gifted a lot of money away. When we're talking about Medicaid, though, Medicaid does not care that there's that $16,000 exemption. They don't care what the IRS says. It may come as a shock to absolutely no one that federal agencies and the government agencies don't always abide by each other's rules for their own internal purposes, right? So Medicaid doesn't care that there's a $16,000 exemption. They say for Medicaid purposes, it's zero. So if you give anything away, in theory, in the 5 years before someone needs care, that can be a problem. And so it's very important to know the risk of doing so. So gifting without talking to somebody first is very important. Knowing whether the power of attorney that you have, for that person, whether it includes the ability to plan around long-term care expenses, that's what's really important. And that's what would allow an attorney to help advise you on that and know what to do. So outside of the gifting consideration, though, one of the more practical things that a lot of people ask about is, where do I even begin, right? How do I know that somebody's in the right place? How do I know that this facility is the best for them, or that they have what they need at this facility? And it's, there are so many facilities out there. And if you're not knowing what you're looking for, it can be very difficult to figure out what facility is the right fit for somebody. I certainly, without doing what I do, would not know what I was looking for initially either. So when someone may need care soon, first and foremost, if the person has capacity, I would talk to them about their preferences. What kind of things are they looking for that would make them more comfortable in a facility? Do they want, is the quality of food incredibly important to them? Do they want to make sure they have, a good atmosphere, good amenities in the facility, or, maybe closer to home, closer to their loved ones as a physical location, as opposed to the facility that maybe has the better amenities that they would want, but is a lot further away. Those are very important things to know if you haven't had that discussion with a loved one. But other than that, knowing which facility actually has those things or what you're looking for in a facility can be very difficult without having experience in it. So one of the first thing I point our clients to if they end up needing care is talking to a care management organization, somebody who can help them find the right place. These are organizations that are out there that will work with the families and say, all right, what's your care need? What's the situation? What kind of quality of life are you looking for? Amenities are you looking for? And also, what does the financial situation look like? How long, based off of these facilities' costs, would you be able to pay out of pocket? And working with all of those factors can help you find the right place for that person. So it's really helpful to work with these groups because they know what they're looking for. They work with the facilities to make sure that it's a right fit. I did mention just a moment ago, talking about how long someone can privately pay. And this is really important to know before you have someone go live at a facility is what does that facility require in terms of how long they ask for somebody to pay out of pocket before they'll accept Medicaid as a payment. Facilities vary on this. They vary from no private payment at all, meaning they'll accept Medicaid right away, to potentially 2 to 3 years in some cases of private payment. And whether or not your loved one will be able to pay for that is going to depend a lot on, one, their income in retirement, but also two, their assets that they have. What's the difference between their cost of care and their income? Is there a $7,000 deficit between their income and their cost of care? Is there do they have a surplus? Would they be able to pay indefinitely? Those are very important things to know. Some facilities, by the way, don't ever accept Medicaid. So that's also very important to know. I've unfortunately in the past had clients have their loved one, before they came to talk to us anyway, had them in a facility that either they didn't have the amount of money that they would need to get through that private pay period, or the facility they were in didn't accept Medicaid at all, and they definitely were going to need it at some point. So it's very good to know what those requirements are first and whether your loved one could need it, because it doesn't help them to be in a facility that they can't potentially stay in long term if they don't have the financial situation to do that. It can be harder to move to a new facility if you've already exhausted funds. So it's very important to look at that first. And that's again where somebody, the care management organizations or the attorney, elder law attorney you're working with could really help you figure that out. So that's where earlier I mentioned it's very important to do it as soon as possible, to have those discussions, because you can get a better picture then with the current financial situation before it's too late. So knowing how to pick the right facility is not something that you would be expected to do. That's why there's professionals out there to help you. Another way that a lot of people will look into paying for long-term care is, many years before they need care, potentially decades before they need care, they'll look into what's called long-term care insurance. So long-term care insurance, if you're not familiar with it, is essentially an insurance product that pays specifically for at-home, assisted living, or skilled nursing care. And it'll usually pay a maximum amount or a maximum period of years. It depends on the policy. It'll have a daily benefit, things like that. So if that is something that somebody would need to help pay for care, because it would give them a longer period of time that they could privately pay potentially, one of the first things you'll want to ask your loved one is, do you have that type of policy? Do you have long-term care insurance? It's one of the first questions that we ask people, for example, when somebody needs care is, do they have long-term care insurance? I mean, I shouldn't even say we ask that when somebody needs care. We ask that question even if, we're planning many, many years in the future for somebody, saying that, this is something that could help you. Do you have that product? If they don't have it, that just tells you a little different situation. You'll need to plan around that lack of insurance coverage and instead look at a different way to privately pay. But if your loved one has that policy, that can be very helpful to get somebody through that private payment. So knowing whether it exists is very important. Asking your loved one, do they have that product? Do they have that type of insurance? Is a really good thing to know. So when we're talking about, after someone's in care, a lot of times people will talk about, okay, they're spending down. We want to make sure that they have, a good quality of life going forward. Once somebody's on Medicaid as a single person, they're only allowed to keep, in terms of income, monthly income, $45 a month. So when people want to make sure that their loved one has a good quality of life going forward, that they have things above and beyond what Medicaid would pay for. Maybe they really like to go out to eat once a week, and $45 a month isn't really covering that. I couldn't imagine that it would. Or that they really like certain TV show and they really want to pay for that subscription service, and the facility doesn't provide it, right? And Medicaid won't pay for it. That kind of thing is important to know. And how do you pay for that when someone only has $45 a month? So this is where people will look at, gifting or protecting assets from care. Again, I would not recommend doing that without talking to an elder law attorney, estate planning and elder law attorney, on how best to do that so that you're not unintentionally causing problems for your loved one. But if you're able to plan prospectively, you can protect some assets from spend down so that somebody is able to actually have that money set aside to supplement care if they need it. The other thing, though, is if somebody doesn't have that prospective time period, they may need care tomorrow. That's again where that financial power of attorney is going to be very important to know, does this allow me to do this type of planning as that power of attorney agent? And if it doesn't, does my loved one have enough capacity to sign an updated one that will allow me to do that if I need to? So that's a really good way to plan for care prospectively or in an emergency situation at the direction of an elder law attorney. My number one disclaimer for everything is don't listen too much to what you read on the internet or what someone told you about, or that isn't an elder law attorney, because that can be, unfortunately, that can be just flat out incorrect. They may be talking about rules in a different state if we're talking about the internet, and you don't want to rely on those rules without being, advised by an attorney of your own. So one of the things that people will often try to do, though, to prevent someone from going into a facility, sooner, and maybe prolong or delay that process, keep them at home as long as possible, is they'll often try to provide care at home for them as a loved one or a family member. There's a lot of things about that type of arrangement, though, that can cause problems if you don't have the right documents in place. So a lot of times it's a child or somebody in the family, not necessarily a medical professional in the family, but that doesn't matter for this. The loved one will say, well, I want to pay you for this because maybe you're taking time off of work to help me, or, you're doing so much, I want to compensate you for it. What's very important, though, is to not make payments to a loved one for that care or to the family member at home without a proper agreement in place. Medicaid will look at those payments, if the right agreement is not in place, as a gift. Even though you are paying somebody for a service they're providing, if it's to a family member and they just see this monthly amount going to this person, Medicaid will assume that they were trying to gift money and hide it. So if you are a child caregiver or a family member who's caring for a loved one and you are getting paid for this, it's very important to have what's called a caregiver agreement in place. What a caregiver agreement is essentially an employment contract saying that, I, the loved one, am paying my family member X, hourly rate for X hours per week or per month, and here is how I'm paying them for that, so that it shows that that agreement is in place and that it is actually a payment, not a gift, right? That agreement must be notarized, right? It can't have any sort of lump sum balloon payments in it. It has to be based off of an hourly rate. It's very important to, follow those rules. What that agreement does is it makes sure that if Medicaid questions those payments, there's proof to the contrary, proof that it is actually payment, not a gift. So knowing how to set that up, again, talking to an elder law attorney would be able to help you with that. This is another thing that's very important to find in the financial power of attorney is, does that power of attorney allow somebody as the power of attorney agent to sign or set up a caregiver agreement? If it doesn't, it could potentially be an issue and not something that they could set up for that loved one. These caregiver agreements cannot be retroactive. So if you are already receiving payment and don't have it in place, there's no real way to cure that problem unless you give all that money back, right? But going forward, at the very least, putting it in place would prevent the future payments from being a divestment for Medicaid. But if you haven't started those payments yet, absolutely look into getting a caregiver agreement in place first before those begin. Now, the person receiving those payments does have to report them as taxable income. So you can't not report it on the taxes. That is, payment, right? Or it's income coming into them. So they'll have to pay taxes on it. But it's better than causing a problem for the person who needs care. Also be careful, as if you are that loved one who may need care, be careful about compensating someone for those sorts of things by paying for things for them. Like, don't buy gifts for them or pay for their groceries to compensate them for that. Because again, that's something where Medicaid could ask, why were you paying for this? Why were you gifting money to somebody? Make sure that if you do need to pay somebody, you are doing it through the proper channels. Through that caregiver agreement. So one of this has to be in writing too. It is not something that you want, verbal contracts. Verbal contracts are not going to hold up in terms of a Medicaid arguments. So make sure that you have this agreement in place and talk to an elder law attorney about what you need in that agreement. Don't just download it off the internet and say, yep, this is a caregiver agreement, because odds are it's not going to qualify and you need advice on how to set that up properly. No lump sum payments. Make sure the child is, if it's a child or a loved one, that they're reporting as income taxes and that it's based off of an hourly rate and it's a notarized agreement. A really big problem that people accidentally create is when they promise a child or a loved one a percentage of the estate to compensate them for that. It's true that, hey, if there's money left and I give you a larger percentage of the estate to compensate you for the care you've provided to me, it's true that that's not a gift, right? That's not a divestment for Medicaid, because you're not making that divestment during your lifetime. It happens after you've passed away. The problem, though, is that there's no guarantee that they'll actually receive payment that way. It doesn't matter if you receive 50% of an estate or 75% of an estate if that estate is spent down to nothing after care costs have been covered, after someone's paid out of pocket. So that's not the best way to compensate somebody. It's not to promise them a percentage of the estate. So there's nothing wrong with paying a loved one for providing at-home care. That's the best way to make sure that they're compensated for it. It's just making sure that the proper agreement is in place and not relying on, kicking the can down the road potentially. And again, this is absolutely something that you want to do as soon as possible if it's needed. Don't start payments first and then try to fix it retroactively. That can be an absolute mess potentially. One question I get a lot, and I can understand the logic behind it anyway, is if somebody takes withdrawals from their account and it's cash, and they say, well, what if I give cash to somebody? They're not going to know, Medicaid being them, they're not going to know that I gave that cash to somebody. I understand the reasoning behind that, but unfortunately, Medicaid will still see the bank records of cash being withdrawn. And let's say it's just cash in a safe that hasn't been withdrawn for many, many years. You still have to report that to Medicaid. And if you don't, there's fraud, being committed. And so it's not worth committing fraud over trying to hide those divestments. Everything you do, you want to be above board. You don't want to commit a crime doing it. You want it to be above board. So I would not rely on cash gifts as a way to skirt the rules around Medicaid. That can be just as dangerous as any other type of divestment with a paper trail. And it's certainly not something that I would lie about for somebody on a Medicaid application. So making sure that is, again, everything's above board is very important. In terms of gifts, a lot of people will ask us about making a gift of the home to the kids. Should I just put the home in the kid's name? This is a really, really probably one of the most common questions we get on planning for long-term care. So I've already talked about gifts potentially causing divestment problems for Medicaid if they're done within the 5 years. But even if the home was gifted to the children or the family members 15 years ago, before that person needed care, there are still really 3 big reasons why that can be a bad idea. First and foremost, and again, I would hope this would never happen to somebody, but if the people they've gifted that home to, if they put the home in the kid's name or somebody else's name to try to protect it, that person is in control of the home. They own the home, which means that person who used to own the home is now really nothing more than a tenant. This is where you hear those horror stories of somebody evicting, their parent from their home or charging them rent or selling the home and saying, you got to go find somewhere else to live, right? It can be a huge loss of control. So it's very important to, set it up in a way where that's not a possibility. But unfortunately, it can happen if you just put the home in someone else's name. Now, that being said, I really do hope that wouldn't happen to somebody, but there are stories of it happening. The second big reason is it's a really bad tax idea to just gift real estate over to somebody. When you bought your home or built your home, however you paid for it, the IRS says, based off of what you put into the home, what you bought it for, your cost of building that home, that's your cost basis in the home. What that means is when you sell the home, the gain on it is calculated by the difference between that cost basis and what it sold for, or potentially a loss, right? Too, if it's less than you paid for it. But everybody who owns their own home, lives in that home, it's their primary residence. They get a $250,000 exclusion from capital gains. But if it's not your primary residence, or if it is, like a second piece of real estate that somebody owns, almost like a vacation home, then they don't get that $250,000 exclusion from capital gains. When you gift property over to somebody that has a cost basis, when you just transfer it to them, their cost basis, according to the IRS, is exactly what yours was. It transfers over to them. Now, if they sell the property after you've passed away and they don't live in the property as their primary residence, they will have capital gains tax almost certainly to pay on that sale. Because the odds are the cost basis is relatively low compared to current fair market value for most people if they've lived in their home for a long time. The better way to transfer real estate is to have the kids inherit it, because at that point, the IRS says, all right, whatever the fair market value was at the date of your death, that's what their cost basis is. So then if they sell it, there's either little capital gains to pay if it's, they've held onto it for a while, or potentially none if they sell it relatively quickly. So tax-wise, it's much better to have someone inherit real estate than it is to just gift it to them. But the biggest reason that gifting the home to somebody is very dangerous is not, the tax side of things is sure something to worry about, but it's more about the unforeseen things that can happen to those now owners of the home. Whatever happens to the owner of a piece of real estate happens to that real estate. So what I mean by that is if somebody gets sued, or they file for bankruptcy, or get divorced, or pass away, right? That happens to the home. So if you gift the home to the 4 kids, and by the way, this is based on a real life scenario. We had somebody come in who they had gifted the home to the 4 kids, many, many years ago. It was well past the 5 years. That wasn't the issue, but they gifted it to their 4 kids. In the meantime, between when the parents of the children passed away and the gift, 2 of the 4 kids had passed away as well. So with one of the children, that 1/4 of the home went down to a son-in-law, which wasn't the issue here. But one of the other daughters passed away and was a single parent. That grandson inherited that 1/4 of the home then. He was a single child as well. But that grandson, when he inherited it, had a major substance abuse problem. And when it came time to sell the home, the family was concerned about him receiving funds from it because he would potentially and very likely use it for his substance abuse problems. So that's the kind of thing that can happen, though, if you're not planning prospectively for that, if you're not accounting for those things. Things that you could deal with through proper legal planning, but just by transferring the home over to the kids is not going to deal with that type of issue. And again, you hope that never happens, but it is a real example of that. Okay, so I'm going a little over time for everybody here, but I will wrap things up for you. And just as a reminder that in 2 weeks, we have our in-person public seminar in Oshkosh. You can sign up for that at oshkoshestateplanning.com. If you have any questions that we didn't have time, let me know. You will also receive a handout by email after this, where if you would like to come in and talk to us, that will give you a place to sign up for an initial consultation. Our initial consultations are complimentary. We schedule them for about 2 hours to give us enough time to talk through things, especially if you have a loved one who is in almost immediate need for care or very likely needs care soon. I would highly encourage you to do that. Come in and talk to us. So other than that, I don't see any questions, but I will wish everybody a happy holiday week coming up. Have a happy 4th of July, and I will see you guys